Good day and welcome to Foley and Lardner's Automotive Privacy Web Conference. Today's conference is being recorded. At this time, I would like to turn the conference over to Mark Aiello. Please go ahead.
Welcome to today's webinar. This is Mark Aiello. I'm co-chair of the automotive industry team for Foley and Lardner. Today's webinar will address automotive privacy and security compliance. Today's program will run for 1 hour, and we will apply for one general CLE credit. All New York, New Jersey, and Kansas attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code that will be announced at some point during the webcast. The attorney affirmation form in today's slides can be obtained in the handout section on the right side of your screen. Questions can be submitted during the web conference by entering them in the Q&A box. We'll answer the questions at the end as time permits. Today's speakers are Chanley Howell and Adam Losey, both of Foley & Lardner's Privacy, Security, and Information Management Practice Group. And with that, I introduce you to Chanley and Adam.
Thank you, Mark, and thank you, everybody, for joining us. We hope this will be informative for you. My name is Chanley Howell. I am in the Jacksonville office of Foley & Lardner. I've been practicing for about 25 years and 23 of those years with Foley & Lardner. Adam, why don't you introduce yourself? And I think you had a little housekeeping, a few housekeeping items to mention.
Sure, and my name's Adam Losey. I'm also an attorney here at Foley & Lardner. We appreciate you taking the time and effort to attend the conference today, and it's always difficult for us as speakers on a webinar to compete with the internet. And the internet is very interesting, but we promise we've taken time and effort to put together a really great presentation for you today that's interactive in parts. And we would really appreciate and think you'll get a lot more out of this if you take the time to participate in the presentation. And there's a little chat box that says Q&A. And we'd really encourage you to take the time to chat, type in questions, and interact with us so that we can help you get more out of the experience than just a cold lecture.
Okay, so with that, we'll get started. First, I will give a brief overview of what we will be talking about today, the so-called rules of the road. We will be reviewing legal compliance issues in the privacy arena related to the automotive industry. We will talk both on a general level with respect to privacy and security matters that impact just about every company that deals with personal information. And then we will also drill down and deal with issues that are unique to the automotive industry, particularly things like location-based services, telematics, event data recorders, privacy implications that arise out of the automotive industry in particular, and connected cars. But we will be dealing with on both the general and specific level, so we, as Adam mentioned, we'd be glad to entertain any questions as we go along. We'd be glad to entertain any questions and hopefully can answer them. So this first slide is just an overview of the sources of information of privacy laws. You may be familiar with much of this information. The U.S. scheme is more of a sectoral approach, meaning it does not have a comprehensive data privacy law, either on certainly on a federal. It would need to be federal if it were going to be comprehensive. Unlike the EU, which has a Comprehensive Data Protection Act. You may be familiar with some of these acronyms in the alphabet soup, as we call it. The Fair Credit Reporting Act deals with credit reporting agencies, and as we'll talk a little bit later, really has a much broader application than just the credit reporting agencies, and many, many companies can be covered under the Fair Credit Reporting Act and not know it. The FACT is part of the Fair Credit Reporting Act. Graham-Leach-Bliley Act deals with financial information, HIPAA with health information, FERPA with educational information. Those, if you are a service provider in those industries, may be applicable to you. Then we have the Telephone Consumer Protection Act and the CAN-SPAM Act, both more marketing privacy type laws that again are of general application to all companies in the U.S. that are involved in marketing campaigns. Then on the state level, we have 46 or 47 security breach notification laws, so that if your organization is, or if your customer or your vendor or service provider is the victim of a security breach, there are reporting notifications. Many states have Social Security number laws that limit how Social Security numbers can be shared. And there are many states that have data security laws requiring at least a reasonable level of security to protect personal information. And then two in particular of note are the, let me go back here, are the Massachusetts and Nevada data security laws. Particularly Massachusetts has a detailed data security law that if you do have residents in the state of Massachusetts and collect personal information, if you're not familiar with that, we'll need to be, and we can touch on that a little bit later. Another very broad source of legal requirements and guideline is through the FTC. Very often the FTC will enter into consent decrees with companies that ends up providing a standard of care and reasonableness with respect to privacy and security. The FTC also frequently issues commentary. Well, it will always issue commentary in connection with the rules and regulations that it promulgates, and very frequently will publish guidelines on various topics, and some of those we'll talk about today. Finally, there's court cases and precedents is another source of the laws. I'm going to talk briefly about the FTC report in March of 2012. If you do not have this and are interested in privacy and security in your organization, I would highly recommend that you obtain a copy of this. It's relatively easy to find on the internet. Probably the most important aspect of the 2012 FTC report is the concept of privacy by design. This is a concept that Ann Cavoukian, the Information and Privacy Commissioner in Ontario, really started to get the concept of privacy by design in the forefront. And since several years ago, the FTC and other regulators in the U.S. and frankly regulators and data protection authorities around the world have embraced this concept of privacy by design. And basically what privacy by design is that organizations should think about and build in privacy at every stage of a product or service development. In other words, don't leave the privacy compliance to the end of a project when a new product or a service or a marketing campaign or a web-based service or marketing or promotion is being developed. The privacy team, legal and compliance and information technology, and whoever else is on your privacy team should be heavily involved in the development of the product and service. So there should be consumer privacy considered throughout the organization and at every stage of development of the products and services. There should be robust and substantive privacy protections in the practices. For example, data security. We'll talk more about it. I mentioned the Massachusetts data security law. Security, you cannot have an effective privacy program without good information security. A concept that we're seeing more and more of, and we'll talk a little bit later about the GAO report that is specific to location-based services, but a concept that has been around in the EU, the European Union, for quite some time and is now becoming more and more important in the United States, is that there are reasonable limits on collection. In other words, it's frowned upon by the regulators and can lead to issues if you are collecting more than you really need. And the days of collecting as much as you can collect are over, or at least the more you collect, the riskier it is and the more compliance issues there are. Similarly, the FTC and other regulators and laws in the United States are dealing with retention and disposal practices. So it's not just collect it and retain it for years and years and years. There is developing and becoming an affirmative obligation to destroy and delete information when it is no longer needed for legitimate business purpose. And finally, the FTC reports about the report speaks to the importance of data accuracy. The FTC report also talks about choice. So if there are areas where the consumer has a choice about how his or her personal information will be used or shared, that choice should be very clear to the consumer, and the consumer should be able to exercise that choice very easily. And finally, I would say almost as equally as important as privacy by design is the concept of transparency. We are hearing more and more about the concept of transparency, and it is a very important issue to the FTC and the other regulators. Basically, what transparency means is that notices of privacy practices should be clearer than they have been in the past, shorter, more standardized. For example, there are various movements to make privacy notices, at least a portion of them, more like a nutrition label, where consumers can quickly look at a table or a box in a privacy notice, and through various icons or symbols or very readable text, be able to quickly understand, okay, this is the type of information that is collected, this is how it's used, and also notifying whether or not the information is shared with third parties for marketing purposes. So this brings up, and we'll talk a little bit more about notice. There's an inherent friction between notices being short and easy to understand, but also being complete and comprehensive. So the FTC and other regulators, you hear about the notices need to completely describe the privacy practices. Well, privacy is a complicated concept, so there is, on the one hand, the need to be short and concise, and on the other hand, the need to be detailed. And so those are issues that are important to consider. And finally, consumer education. A good example of this is the FTC and other regulatory agencies in the U.S., but the effort is led by the FTC, has a very good online source called onguardonline.gov. And so that's a good example of consumer education. The FTC report also talks about the importance of affirmative opt-in consent for location information. We'll talk more about location information, but just so everybody understands, it is considered sensitive information along the same lines as health information, social security numbers, financial information, credit card information, information about children. So the FTC views location information in that same bucket as sensitive information, which results in a higher degree of diligence being required in dealing with that type of information. The FTC report talks about, again, I mentioned earlier, limiting collection to only what is needed for the service or transaction that is requested by a consumer. Keeping reams and reams of personal information in the event it may be needed in the future for marketing purposes is not a practice that is smiled upon by the regulators. And if there is a security breach involving that information, it can cause legal issues, both with the regulators and with individual plaintiffs or class actions. There should be prominent notice, particularly where personal information is shared, and we'll see notice it can be a particularly thorny issue when we're talking about some of the in-car based services that we're seeing these days. The FTC report also talks about do not track. Now this in particular is in the context of tracking individuals in their online internet activity and not necessarily the location. Obviously, location is a very important aspect, but typically these days when we talk about do not track, it has to do with tracking an individual's online activity across multiple websites and then providing them with interest-based ads and basically building an online profile of an individual about their interest, the pages they visit, the products they look at, the search terms that they enter. So there is some sensitivity in developing and using those online profiles. And finally, mobile, which we've talked about and obviously implicates things like location data, the difficulty of providing notice in a mobile environment. And then the NTIA report, I will turn it over to Adam to tell us about this.
And this is a report from February of 2012 called Consumer Data Privacy in a Networked World, a Framework for Protecting Privacy and Promoting Innovation in the Global Digital Economy. And as those of you who have worked in this space, those can kind of be somewhat competing interests, in that a lot of innovation that you may want to undertake at your companies or that a lot of automotive folks want to engage in can sometimes clash with some basic privacy objectives. And this report opens with a letter from the President of the United States saying the Americans have always cherished their privacy, and it closes with a conclusion saying the United States is committed to protecting privacy. And the report makes really clear that data privacy is a modern political priority. It's a 62-page report. If you want to email one of us, we can send it to you in full, and it has something called the Consumer Privacy Bill of Rights in it. And this Bill of Rights applies to personal data, and they have a really broad definition of personal data. They call it any data, including aggregations of data, which is linkable to a specific individual. And as we'll get into later, with that kind of breadth of definition, even if you aggregate data, you can always, well, sometimes trace back aggregate data to specific individuals. The Privacy Bill of Rights has 7 points to it. The first is control. And the Bill of Rights says that consumers should have a right to exercise control over what personal data companies collect and how they use data. And as we'll talk a little bit later, sometimes that can be kind of tricky to meet when you're having forward-thinking privacy policies and you're not sure necessarily what exactly you're going to use data for next week. Transparency is the second part of the Bill of Rights, a right to easily understand and access information about privacy and security practices. Type into the Q&A, by the way, if you've ever seen any congressional hearings on privacy with Al Franken, grilling some companies about transparency, because I've seen a lot of videos on it. I have a friend that was grilled quite heavily by Senator Franken, and they look at a website or at a privacy policy and will say if something is 10 clicks away or 7 clicks away from looking at an online policy, or if it's buried in the fine print, how is that transparency? But the converse is, again, like Shanley mentioned, privacy is very complicated. It's really difficult to concisely and easily tell consumers everything that you could possibly do about their personal information and how you keep it secure. The third part of the Bill of Rights is respect for context. And it says consumers have a right to expect that companies will collect, use, and disclose personal data in ways that are consistent with the context in which they provide the data. And that's kind of a subjective analysis, really, right? What is the context in which you're collecting it? A good example would be if you collect email addresses for a charity or something like that. It would kind of be out of context to take those email addresses and sell them to a third-party marketer trying to sell televisions. Security is the fourth factor, and consumers have a right to secure and responsible handling of personal data. And that is also largely covered by a lot of state data breach statutes that have certain notification requirements that apply if you have a breach. Access and accuracy is the fifth factor, and it says consumers have a right to access and correct personal data in usable formats in a manner that's appropriate to the sensitivity and the risk to the consumer if the data is inaccurate. Focused collection is the sixth, a right to reasonable limits on the personal data that companies collect and retain. Again, the lawyer's favorite word in a subjective term, reasonable limits. 7, accountability. Consumers have a right to have personal data handled by companies with appropriate measures in place to ensure they adhere to the Consumer Privacy Bill of Rights. And so let me ask you, and I'm opening a poll here, which you should be able to see in a moment. Does the White House report constitute a regulatory requirement? And if you could, go ahead and click and vote. Is it a de facto executive order? It's signed by the president on the second page. Is it a regulation that you have to follow? No way, you can ignore it, or no clue. That's why you're at the CLE. And if you'll go ahead and take a second and vote, and I'm broadcasting the results real time here. It's a de facto executive order, a couple of you say. Some of you say you can absolutely ignore it. And the majority of you say no clue. That's why I'm at the CLE, and I'm glad you're here. And so the de facto executive order, I just made that up. I don't think it's a de facto executive order because the president signed it, but maybe there's some argument out there that it is. It's not really a regulation, and I'd be hesitant to say that you can ignore it. It's not a regulation. You know, it's not passed by a legislative body. It's not a law. But the Federal Trade Commission, the FTC that you heard about earlier, and you'll hear about more later, if you'll pardon my tortured driving analogies, they're kind of the stick in the privacy pothole that pops your tires if you run afoul of a privacy issue. And as this report says, quote, the FTC brings cases based on violations of commitments in its privacy statements under its authority to prevent deceptive acts or practices. In addition, the FTC brings data privacy cases under its unfairness jurisdiction, which will remain an important source of consumer data privacy protection, end quote. And the FTC frequently looks at things like this, at best practices, at frameworks for protecting privacy to figure out what they're going to do on the enforcement end and what's reasonable and isn't. Because again, they've got a really broad unfairness jurisdiction that while this isn't an actual regulation that you have to follow, the consequence of ignoring a lot of these factors in the Privacy Bill of Rights can be almost the same as ignoring a regulation, in that you will see some kind of enforcement action. And also, from the GAO report, it parses sorry about that. The 2012 report was mentioned specifically in the 2013 report that you may have seen in your email invitation to this conference. The GAO in-car location-based services report titled Companies Are Taking Steps to Protect Privacy, but Some Risks May Not Be Clear to Consumers. And that study, which actually I bet some of the folks attending this CLE may have even participated in this. They talked to 10 companies, automotive manufacturers, navigation device makers, and others, all of which collect location data. And what the GAO found, they broke into in the beginning into 4 bullet points that are reflected in this slide. The first is disclosures. And the GAO found that consistent with the recommended practices, all of the companies disclosed that they collect and share location data. That's not a big surprise. But inconsistent with the practices, the GAO found that 9 of the 10 companies' disclosures provide reasons for collecting data that are broadly worded. Thus, they're not exhaustive, according to the GAO. And 5 companies' disclosures didn't describe the purposes that you're sharing de-identified location data for. And the GAO says, look, without these clear disclosures, there's a higher risk that the data may be used for something that the consumer didn't really have full knowledge that they were consenting to, weren't expecting, or might not have agreed to. And again, that's that tension. You want really, part of you wants broad policy so that you can do what you like with the data and it leaves you flexibility. But the push has been towards a little more specificity, because if you simply say we can use your data for whatever we want to, sometimes there's the thought that while it's broad, it's not specific enough that the consumer would have any idea that, for example, you're selling it to somebody for marketing purposes. Consent and controls. Again, consistent with the recommended practices, the study found that all the companies obtained consumer consent to collect location data. And all of the companies offered the consumer some control over location data collection. However, if the companies kept the data, they didn't necessarily allow the consumers to request that the data be deleted, which is a recommended practice. And as we'll talk later, we're seeing some laws pop up that actually could apply to the automotive industry that do require certain data to be deleted. Safeguards and retention, as Chanley mentioned, privacy and security are parts of the same puzzle. You can't really have privacy without security, right? If you can't keep it secure, then it's not private. And all of the selected companies do take steps to safeguard location data, all 10 of them. But they use different de-identification methods that affect the extent to which consumers can be re-identified and exposed to privacy risks. And there's a pretty wide variation in how long companies retain specific data. Accountability, which is the fourth bullet point. All of the selected companies disclosed to consumers or took steps to protect the location data that they shared with third parties. And we're going to get a little more into dealing with third parties and providing data to them later on. And that's consistent with recommended practices. But inconsistent with the practices recommended in the report, none of the companies disclosed to consumers how they hold themselves and employees accountable. And let me ask you on the topic of consent with another poll. How do you obtain express written consent from a driver and all passengers for data collected related to the use of an automobile? Use point-of-sale contract language for when you buy the car, pre-drive push-button consent. You know, to start the car, you have to consent to these privacy policies. Clearer policies at sign-up pre-collection of data. So, you know, if you have separate from the actual operation of the automobile some sort of computing or electronic device that needs to be turned on, some kind of button there. Or is it not always possible? You can't say that you're always going to obtain express written consent from the driver and all of the passengers. I'll broadcast the results here, and some of you have actually changed your answers a couple times, and that makes sense because you're probably trying to select multiple, and I don't think you can do that based on how the webinar works. But you're right. You can obtain express written consent in all of those ways, but as most of you are saying, it's not always possible. All of the above help, but how are you going to obtain express written consent every time somebody jumps in the backseat of a car? It's not practical a lot of times. And anybody heard, by the way, and type in the Q&A if you have, of Project MOBII, MOBII, and this is a public thing that I read about, in a conceptual phase with Ford and Intel pairing up to make cameras that actually point at drivers and at potentially passengers. And, you know, that's a great example of something that can allow people to interface with, you know, a variety of communications devices. Heck, one day maybe you'll be able to order a pizza from the road. But there's a lot of privacy issues there, and it's hard to obtain consent from everybody if you've got a camera pointing somewhere all the time.
Yeah, Adam, I have something to, if I can just jump in real quick.
Sure.
Yeah, on the, you know, the foundation of privacy law pretty much throughout the world is basically a notice and consent framework where a consumer consents to how, you know, what personal information will be collected, how it will be used, and with whom it will be shared. That is becoming more and more difficult, and as we get into things like that Adam was just speaking about, how do you get consent in connection with information collected by a car. This is in the realm, and you may have heard of the Internet of Things. The FTC has had workshops on the Internet of Things. It's becoming a more and more common term. A car is a thing that's connected to the Internet, and as technology progresses, there'll be more and more items. I'm sure you've heard about them either in your casual reading or in your practice. You've got refrigerators, you have thermostats, door locks. The number of devices and things that are being connected to the Internet every day are tremendous. So there is a debate going on in privacy circles. Is the notice and choice framework dead? Because you can't provide notice, or it'd be very difficult on a refrigerator. It can be even difficult in a car. Not all of the systems have the screens, and even if it does have a screen, you have the problem of providing an effective notice on a relatively small screen. So is notice and choice dead? The debate is between notice and choice on the one hand, and then limitations on use on the other. So as the argument goes, if we can't get notice and choice, or if notice and choice is not effective, maybe because privacy notices in themselves are simply not effective because people don't read them and they're too difficult to understand. If notice and choice doesn't work, let's put limits on use and accountability, and limit how a company can use the personal information. And if they use it in a way that's not permitted under the applicable law or regulation, then there's consequences. So I think, and I think most people believe, it's a combination of both. That notice and choice is not dead. It's not going to die anytime soon. But it does mean, with the difficulty of the whole notice and choice scheme, that we will see more limits on use. So the Fair Credit Reporting Act is an excellent example of limits on use. There are limits about using credit report type information and credit worthiness information for marketing purposes. And if it's used for marketing purposes without authorization, then there's a violation of the law. So I just wanted to point that out, Adam. Thank you. Back to you.
Yeah, and totally agree. And there's also, quite the tension between, this says in-car location-based services, and you see this is from the GAO report. It's parsing different systems. I'll get into it in a second. But when you see this, you think GPS, right? Portable navigation devices, how to get from here to there. But as technology advances, it's going to be more than that. I mean, there's a lot more to location-based services than just how to get from here to there. I'm a good example. I'm a consumer that actually bought my car because I liked the technology with it. It came down to a couple cars. I'm not going to say which one won, not to offend any automakers here if one of you manufactured the competing car. But I made my choice based on the fact that I liked the technology, I liked how seamless it was, and I think more and more consumers are really going to care about that. And the more in-car, location-based services and technologies that you have, the more of a competitive advantage you'll have. And so the GAO report parses telematics, PNDs, and maps and navigation applications. Telematics use GPS data and kick location data through a cellular network or Wi-Fi and give services through the system. Again, directions are fine, but it can be a lot more than just directions. It can be emergency services. If you crash the car, the telematics system can call a paramedic. That's one example where, notice and an opportunity to opt out may be difficult. Somebody rents a car and they crash it. Do you want them to have to agree that you can call 911 on their behalf, or do you want to call 911 and dispatch it to the GPS data on the telematics? Again, one day not far off, I think we may have Papa John's doing pizza delivery. Or Amazon was even talking about delivery with drones, order something to your car. PNDs, again, like a Garmin system, if you're familiar with it, or TomTom, those are separate and less integrated with the automobile. They can be free or subscription-based, and typically they're for navigation. Mobile devices, the last one, for example, Google Maps, these have really taken a chunk out of a lot of the other services. Google Maps and Apple Maps are free utilities, and they're great for finding your way from A to B, although Apple Maps did tell my wife to drive into a body of water once. Luckily, she did not. So what good is location data, aside from user value? Traffic? Sure, think Google Maps traffic. Performance? For the automaker, I mean, do you want to measure certain performance issues? Does the electrical plant, when everybody drives by that, do they have issues with their car? Marketing? Do you care who goes to McDonald's every day or want to sell that information? And finally, money. You want to sell it and make some money from various location data that you're able to collect. Traffic is a great example of one of them. Performance is another one. Marketing and money, those are all examples. And they're all used. I mean, Google Maps traffic, certainly. Telematics data is used to measure traffic. Money, yeah, absolutely. This data can be very valuable to people. Where people are going, where they're driving. Heck, even, I mentioned who goes to McDonald's every day. I'm sure that there might be some value to a lot of big companies about, do users slow down when they pass a sign or when they pass a billboard? So location data has all kinds of value, and it can have direct dollar value, which can create issues, obviously, if you want to sell location data associated with consumers and you haven't disclosed that to them. Generally, there's, I think, Shanley, I'm curious what you'd say about this too, kind of a negative view of just straight selling consumer location data for a profit to a third-party company. Even if you disclose it, it just seems to be a negative connotation with doing that, although it can be pretty valuable. And Shanley, I'm curious to hear your thoughts on that, and also Shanley will walk through the data flow on the next slide here.
Sure. Yeah, clearly whenever a company is selling or transferring personal information to a third party for the third party's marketing purposes, that's obviously it's done, and it can be a very good way to monetize data, but it does get you into a higher risk area. With location data, as I mentioned earlier, location data is viewed by the FTC and in many laws that are being considered on a federal level for data privacy and security. Location data is being put in the bucket of sensitive information, so that even raises the stakes further. Under the EU, for example, and the U.S. is moving closer to the EU, and particularly in light of the NSA spying and trying to keep the cross-border transfer protocols and the safe harbor in place. But for a number of reasons, there's a general move by the U.S. to get more towards the EU and to get closer to the EU. But whenever sensitive data is collected, it requires opt-in consent from users. So we're not all the way there in the United States, but we certainly are. You see it all the time on your iPhone or other smartphone, that there'll be a pop-up just-in-time notice that asks if your location data can be collected. They're not the providers and the app, the phone providers and the app developers are not doing that just out of the blue or for no reason. They're doing it because that is now expected of them. So when you're dealing with sharing of location information for marketing purposes, there really should be a clear opt-in to allowing that, and then also the ability to easily opt out of that. This next slide is again out of the GAO report, just shows a typical data flow. Again, the data, first the car is located by the GPS, the global positioning satellite. That information is then sent to the cell tower or the Wi-Fi access point, which in turn can go to any organization that is accessing that information. And there can be any number of third-party partners or contractors that have access to that information. So the importance of the privacy is not just for the automobile manufacturers or the navigation device manufacturers. It's really any company that is in the chain of handling personal information. Because if a company has personal information, it needs to be confident that it has the ability to use the information for the purposes that it intends to. And a lot of times, that's not in the control of a company down the chain that obtains personal information, and it's typically going to be handled at the front end with whatever company, for example, the OEM, whichever company has the relationship, the customer-facing relationship with the consumer, will need to obtain the appropriate rights to collect and use the personal information as desired. So and the other point I wanted to make, and Adam touched on this, the GAO report and a lot of what the last couple of slides we've been talking about focuses on location data. But keep in mind, it's more than location data. You can have sensors all throughout the car. You can have them in the wheels that tell how fast or how quickly the wheels are rotating and how fast the cars are going. You can have them in tires to sense the tire pressure in the tires. You can have them in engines that sense all sorts of data about the engine performance. And all of that data can then go into the, quote, black box or the event data recorder that once it's collected, it can be then beamed out and transmitted for others to use. Adam, back to you for the industry-developed privacy practices.
Sure, and again, this is from the same GAO report, which helpfully talks about industry-recommended best practices. Disclosures to consumers, best practices are simply as put there. State why you collect and share it. State that the collection is limited to specific needs, and don't use it for a reason that you didn't disclose you were going to use it for. So pretty simple practices. The irony of this, and one of the big ironies in the privacy policy world is, have you ever read a privacy policy as a consumer, and be honest? Of course, you read every one you agree to once or twice, normally don't read them. No, I've got better things to do. There was a company that was famous for slipping into their privacy policy or their terms of service for a couple days that they owned your immortal soul if you agreed to their shrink wrap agreement, and everyone agreed to it. Nobody bothered to read it. Many people don't read it, and I think sometimes folks think, well, because people don't read it, it's not important. That really doesn't lessen the importance of getting clear policies and having consent. It's not an excuse that consumers just don't read it. Disclosure is just one part of it. The next thing is control. Obtaining consumers' consent before collecting their personal information gives them control. Give them the ability to opt out of data collection to which they've previously consented. What's their mechanism to do that? And some state laws require that. Allowing consumers to delete location data that's been collected. This was a pain point that the GAO report identified as deficient, and it's another one of those conflicting obligations. If anybody's familiar with e-discovery and data preservation, you can't always just delete something because somebody tells you to. There's all kinds of state and federal laws and common law issues that are associated with the preservation of data. And on top of that, does anybody have a right to be forgotten as to data provided regarding an individual? Is there a right out there to be forgotten? And yes, no. Clearly, I think many of the yeses are from California. We've got 3 yeses and 6 nos. And Chanley, tell us a little bit about the privacy rights for California minors in the digital world, the California Internet Eraser Law, which could apply to the automotive context. Sure.
As you may know, there is a law passed relatively recently within the last year or so called Internet Eraser that gives minors, and unlike COPPA, which is the Children's Online Privacy Protection Act on the federal level, which applies to children under the age of 13, the one in California applies to minors under the age of 18. So you could have drivers that are covered under California law. It basically requires companies that either direct their online services or websites, and it would include mobile applications and online services that are available in cars, but requires the owners of those types of services to provide notice to minors and give them the ability to delete the information, any information that they've posted or provided that's available publicly. So that's something to know about. Also, as you may know, in the EU, and again, as I mentioned earlier, the U.S. is creeping in various ways towards the EU on privacy, but as you probably heard, the EU court recently ruled that Google was obligated to delete certain links to pages under the right to be forgotten, which is a concept under the European data law. So I think there's more that we'll be seeing on that. Data safeguards and retention, we've talked about these issues. Generally, just the guidance that we see from regulators and that we recommend is that consumers should be notified of how long their data will be retained, if it is possible to give a particular time period. For example, if it's location data, based on the service that's being provided to the consumer, it may not be necessary to retain that location data for a particularly long time. Maybe 30 days is enough. On the other hand, if it's a different type of service being provided to the consumer, it may be a longer period of time. You may or may not be able to put a specific time period on it. But the concept is, once you no longer need the information for the services that have been requested or the transaction with the consumer, the information should be deleted within a short period of time after that. There's also an obligation to protect the data with reasonable security safeguards. The Massachusetts law I mentioned requires a written information security policy. The requirements under that law and the typical information security policy and reasonable safeguards that would be required under state and federal law include things like accountability. You need an individual, at least one individual responsible, and typically a team that's accountable for security within the organization. It deals with things like encryption and training and vendor due diligence and oversight of vendors. A big part of compliance and avoiding and mitigating risk is de-identification, which Adam will talk about now in connection with this next slide.
This is one of the recommended practices. I'll walk you through it first. Hopefully you're familiar with the board game or movie Clue. First we have it was kernel mustard in the candlestick, or with the candlestick in the library type of location data, where you have a name and a place clearly tethered to an individual. Then you've got location data where you have a unique ID. Next up, it was number 867 with the candlestick in the library. Were it a murder, the DA could still subpoena you and get the colonel's identity because it's traceable to an individual through the number, but it's more protected. It's a little more private. And then as you move to the right, you've got a little more obfuscation. You've got a variable unique ID. It was number 7 with the candlestick in the library. And 7 changes. You may or may not be able to trace that back to an individual. And finally, you've got no unique ID and total aggregation. So there was one person at the library. Note how I'm making a point with the one person. You can sometimes still trace even, I know it says no privacy risk on the far right side, but even location data stripped of unique identifiers that is aggregated can still sometimes be tracked back to an individual. For example, only one person's at the library there driving a Cadillac CTS with OnStar, and that person's Colonel Mustard. If you know that and you see that there's one person there, you could still identify it with the individual. But on the far right of the scale is as good as you can get as far as anonymization.
Adam, let me jump in here real quick. It's about 10 till. We'll get moving quickly to finish, but also Mark Aiello was going to provide the CLE code. Are you on, Mark?
I am. The CLE course code is GAGO. So again, it's GAGO. Thank you.
And next up is accountability of third-party service providers. Now, all the companies interviewed in this report said they took steps to protect location data shared with third parties. And the thing that they leaned on is, well, we contractually required everyone to follow privacy policies. And I got kind of a chuckle out of that when I read the report. And it's a great practice, and you need to do it. But I can't count, Chanley and I have dealt with quite a few breaches or privacy issues where a third party dropped the ball and they were contractually required to do it. I mean, the big Target hack, which I'm sure everybody is familiar with, that came about through a third-party HVAC vendor. They were the attack vector, which is a term not just for the military, but for hackers. If you're trying to get in or breach security, you typically don't do it through the front door. You look for the vendors, even with physical penetration, a janitor or a maintenance man. So what do you do? The report has some tips, but I wanted to share something kind of off script on the report, in that contractually requiring somebody to do something gives you the right to sue. Sure, and it gives you some cover, but Chanley and I have dealt with this and put a little more teeth into it. And then along with just requiring somebody to be accountable and protect it, make them indemnify you. If they're going to be holding this data and something happens, then they should pay for it. But what's indemnification for some small companies? They may not be good for it. So you couple that with insurance requirements. With you as a named beneficiary, if there's a breach, there's a very robust cybersecurity insurance market. So with third-party service providers, if you can negotiate it, you want to contractually require them to do something, but you also want to have the ability to audit them, you want them to indemnify you, and you want them to have insurance so they can put money behind the promises. Accountability, again, a time frame is a tough point. How long do you need to keep data? What do you think, 30 years, 7 years, 3 years, 43.4 seconds until you don't need it anymore? Or there is no universally correct answer. And in the interest of time, I'm going to broadcast the results. And once there is no universally correct answer, even if you don't need it anymore, and that's kind of a loaded question, there can be regulatory requirements or other reasons you need to keep data. If you get a letter from the FBI saying you have to keep this location data from this person, and you don't need it anymore for whatever reason, you don't want to get rid of it. I think the Boston bombers' roommates, or one of the roommates, was recently sentenced for destroying information related to their activities. There's really no universally correct answer that can be tethered to a specific chronological period. And Chanley is going to talk a little bit now about some of that monetization of data that we touched on.
Yeah, and actually in the final 5 minutes, we've talked about a number of these next following slides. I want to get to really our recommendation for compliance and best practices, so that we've talked about the issues and where there can be risks and where people get in trouble. This is sort of a view of what we recommend on dealing with the compliance issues. So basically, it's 4 steps. Develop a personal information inventory and practices of how the company deals with personal information. Second, identify applicable laws and standards. Third, identify the gaps between the legal requirements and the practices that you would like to or intend to use in connection with the personal information. And finally, remediate those gaps and determine how you will be able to comply with the applicable laws and standards. So developing a personal information inventory, it's basically getting down on paper what categories and types of personal information do you collect, and in particular, what sensitive personal information do you collect. As we've talked about, location data is sensitive, as is health information, financial, credit cards, social security numbers, children's information. All those are in the areas of sensitive personal information. So get that down in a spreadsheet or in a Word document of the types you collect. How do you collect it? Is it collected online? Is it collected offline? Sometimes there are different rules and requirements based on how the information is collected. Where is it stored? Both physically, such as on what servers, in what information systems, what applications, and also geographically. So you need to be able to map where your data is located so that if it's needed in the event of a discovery request, as Adam was alluding to, a subpoena, a regulatory investigation, you know where to find it within your system. But also geographically, there may be limitations, legal limitations, either contractual or under certain laws about offshoring certain data in jurisdictions like India, and certainly higher risk jurisdictions that may be subject to export controls. And also the EU, as I've talked about, and as you probably know, has stricter data privacy and security requirements. So you need to know where it's stored and have that written down in your inventory. You need to inventory the purposes for collecting and the intended uses. As we've talked about, that's important because to give effective notice and choice. The consumer needs to be provided notice of why you are collecting it, how are you going to use it, and if you do want to eventually change the use, then you may need to get new notice and new consent from the individuals. If they have a choice, either you voluntarily give them a choice or by law they have to have a choice, for example, under the Fair Credit Reporting Act, Graham-Leach-Bliley, HIPAA, various state laws, the customer or the consumer may have the right to opt out of certain types of collection and certainly certain types of sharing to third parties. Who requires access? In order to have adequate security, you need to know who is entitled to access because part of security is access controls. There's the security concept of the principle of least privilege. That is that the access should only be given to individuals as is necessary and required for the legitimate business purposes. And finally, and probably one of the most important points, will you be sharing personal information with third parties, particularly other than service providers? If it's a service provider that's helping you provide a product or a service or a transaction to the consumer, that's not as big of an issue as is sharing personal information with third parties for things like marketing purposes or even for research. But that needs to be identified. So then once you have the inventory, you can look down the various laundry lists, the alphabet soup of the laws and other standards that may be required. So we've got, all the list of laws here. You would need to look at the FTC reports and guidance, many of which we've mentioned today. The PCI DSS, data security standards for payment card industry, you may be familiar with. That deals with credit card information. You definitely need to look at your consumer-facing, whether it's online policy or otherwise, but any consumer-facing privacy policy, you will need to comply with those privacy policies, and you may very well need to change those privacy policies if you are implementing a new service. This is the Digital Advertising Alliance on online behavioral advertising. If you intend to track individuals' in internet activity and provide them with interest-based advertising, those guidelines need to be followed. The Mobile Marketing Association has detailed text messaging requirements, which also implicates the Telephone Consumer Privacy Act. So once you've identified those laws, then you can identify the gaps between whether you need new notice or purpose. These are the various privacy principles that we've talked about. And then finally, the last step is to close those gaps. So do your notices need to be changed? Are the consumers entitled to choice? If so, make sure the choices are easily to be elected by consumers. It's very important for consumers to have access to the personal information you have about them. That's a very important point that the FTC and other regulators are stressing, and certainly it is likely that there will be federal laws one of these days when Congress gets back to work, but high on the list is federal privacy and security legislation, which will undoubtedly entail access to personal information. The information needs to be accurate. As I've mentioned, if there'll be transfers to third parties, is that legally permissible under the laws that you've identified? Will you be using de-identification? Adam talked about de-identification. If you will, make sure there's appropriate methods implemented to ensure proper de-identification. And these other items that we talked about, limiting collection and storage, security of the information, documentation, preparing your policies, both customer-facing and internal policies, your notices, etc. And then finally, education and training of employees, because once the new service or product is implemented, your employees need to be educated and trained on the legal compliance issues. So we have reached the top of the hour. We very much appreciate your time and attention, and thank you for joining us for this webinar.
And thank you, Chanley and Adam, for I feel it was a very educational and useful presentation, and thank you to all the attendees.